Good day everyone, especially to our instructor, Mr. Anthony Gamali. I am Jed guys, and in this video, I am going to report or discuss the chapter 1 to chapter 6 of the subject forensic chemistry and toxicology. So without further ado, let's begin. Chapter 1, Introduction. Forensic chemistry is defined as that a branch of chemistry which deals with application of chemical principles in the solution of crimes. Like the other forensic sciences, forensic chemistry plays a very important part in the speedy investigation and in the administration of justice. It is well settled that this science has an advantage over extracted confessions, eyewitnesses, and other circumstantial evidences. Thus, it is regarded as the highest form of uncontestable and conclusive piece of evidence with the utmost legal significance. The value of the findings of a chemist in convicting the guilty as well as in clearing the innocent suspect has long been recognized not only in the criminal investigation and detection but also in courts of law. The forensic chemist is often called to render testimony in court. The scope of forensic chemistry is the science that deals with the study and application of chemical principles in the solution of problem that arises in connection with the administration of justice. This forensic science deals with application of chemistry in the identification of evidence, its physical and chemical properties. It also includes the collection, preservation, examination, and study of blood, semen, and other body fluids, examination of dangerous drugs. Examination of body fluid to determine the presence of dangerous drugs, alcohol or liquor test, examination of fake products for unfair trade competition, arson investigation, macro etching examination, bullet trajectory, ultraviolet examination, tools and other marks, gunshot residues, gunpowder, nitrates, paraffin test, distance determination, and firearms examination. Principles and examination of explosives, hair, and textiles fibers, chemical aspects of document and examination, problems on glass fragments and glass fracture, and petrography as applied to crime investigation. Forensic chemistry also includes the study and examination of DNA. On the other hand, forensic toxicology deals with examination of human internal organs, food samples, water and gastric contents for the purpose of detecting the presence of poisonous substance, its dosage, effects, and treatment. Practice of forensic chemistry. The work of a forensic chemist is divided into 4 stages, namely, number 1, collection or reception of the specimen, number 2, the actual examination, number 3, the communication of the results of the examination, and number 4, court appearance. Collection of the specimen to be examined. The proper collection, preservation, and transportation of specimens are essential in the investigation of a crime. Hence, whenever possible, the chemist should personally collect all the specimens necessary for the examination. This particular stage of forensic chemists' work is essential as questions regarding the collection, preservation, and transportation of the specimen are raised during the trial. Factors that must be considered when collecting specimen for examination. Letter A. Sufficiency of samples. As much as possible, the investigator should collect sufficient amount of specimen for examination. This will take the chemist confident that in case of doubtful result, he or she can still have enough samples to repeat or to proceed to the succeeding examinations. Letter B. Standard for comparison. When the evidence in question is located in or added with a foreign substance, a sample of such foreign substance must be submitted for analysis. For instance, if blood is found on linoleum, a sample of the unstained linoleum must be submitted together with the stained portion. In cases of adulteration or unfair trade competition, a genuine sample must be submitted for comparison. In the examination of hair, textile, fiber, soil, and etc., standard samples must be submitted for comparison. Letter C. Maintenance of individuality. Each piece of evidence must be collected and preserved as a separate sample. There must be no mixing or intermingling of specimens collected from different locations, as well as those standard specimens. Letter D. Labeling and sealing. It is a well-settled rule that evidence will have no value in court in spite of the good report of the expert if the specimen cannot be identified by reason of improper labeling. Hence, each sample must be labeled properly. Small fragments should be enclosed in proper specimen boxes or container, and the boxes should be sealed. The label should include information concerning the nature and source of the sample, date and time of collection, case number if any, and name of the person collecting the sample. Actual examination of the specimen. The first step in the examination of an article is to scrutinize it carefully and write down in the laboratory or logbook or record book a complete description of the external appearance, including the manner in which it is secured and the particulars of the sealing. If possible, take a photograph of the specimen, including the inner wrappings, and take note of its descriptions. A detailed description of the appearance of the contents of the package should be noted and recorded. All wrappers should be kept and preserved, since questions concerning them may be raised in court during trial. The second step in the examination is to measure or weigh the object, and all measurements and weights should be entered in the laboratory logbook or record book. The specimen should then be placed in the proper container or wrapper and must be kept in the proper evidence room. The third step is the laboratory examination, which consists of the chemical, physical, and confirmatory tests. Communication of the results of the examinations. The results of the examination conducted should be communicated with the requesting party in the form of a written report which must include an enumeration of facts on the specimen received for examination with detailed description of the packaging, sealing, and labeling date of receipt and from whom it was received, the purpose of the examination, the finding, and conclusion. Court appearance. The written report of the forensic chemist is usually supplemented by testimonial evidence in a later date if the case is brought to court or the fiscal's office. Since the testimonial evidence may be given weeks, months, or even years after the examination and the written report have been made, it is not only permissible but indispensable that the chemist should refresh his memory by referring to his laboratory record book before presenting himself in court. Role of forensic chemist in the scientific investigation. A forensic chemist, as a man of science, performs laboratory examination on physical evidence submitted to the crime laboratory in order to expedite the investigation of a crime by the investigating party. He or she has the following responsibilities. Number 1. Conducts qualitative and quantitative determination of abused drugs as well as volatile substances. Number 2. Conducts chemical examination of explosives and or explosive ingredients. Number 3. Examination of paraffin, cast, and firearms to determine the presence of gunpowder nitrates. Number 4. Conducts gunpowder examination on clothing for possible gunshot range. Number 5. Conducts chemico-toxicological examination of human internal organs, gastric contents, blood, water, food sample, and other substances. Number 6. Conducts examination of fake products in cases of unfair trade competition. Number 7. Conducts blood alcohol determinations. Number 8. Examines urine samples and other body fluids for the presence of abused drugs. Number 9. Conducts researches related to cases being examined. Number 10. Testifies and gives expert opinion in court. Number 11. Gives lectures on forensic chemistry and chemical toxicology to various schools, universities, police training centers, and investigating units. And number 12. Responds to queries of all investigating units and render expert opinion on matters related to the application of chemical principles for the purpose of assisting investigators to develop investigative leads. 6 golden rules in the practice of forensic chemistry. Number 1. Go slowly. Good work cannot be hurried. Therefore, take all the time necessary to make the case complete, no matter how urgent it may appear. Number 2. Be thorough. Make careful and minute examination of everything and do not be satisfied with a quantitative analysis if a quantitative one is possible. It always pays to do too much rather than too little, and it is difficult to foresee what will or will not be required in court. Number 3. Take notes. Keep a full, neat and clean record of everything seen and done. Number 4. Consult others. Many cases will lead the expert into paths with which he is not familiar, and when this happens, he should consult those who know better. Number 5. Use imagination. An expert with a wide and uncontrollable imagination is considered as the most dangerous creature. Though his being imaginative is sometimes useful, an expert witness does not have to be solely imaginative, but he has to be skilled in the field of forensic science. He must bear witness within the limits of science. Number 6. Avoid complicated theories. The simplest explanation is fundamentally the right one. Interpretation of results is often the most difficult part of the expert's task. That is why a wide knowledge and scientific experience are the essential elements to obtain the right forensic examination results. Equipments used in the forensic examination. The following are some of the most common laboratory equipments used in the forensic examination. Number 1. HPLC, high-powered liquid chromatography. This scientific equipment is used for the qualitative and quantitative determination of a volatile or non-volatile compound based on the chromatographic separation of its components. Number 2. Ultraviolet spectrophotometer. It is used for the qualitative and quantitative analysis of organic compounds. Number 3. EMIT, or enzyme multiple immunoassay technique. It is used for screening of abused urine samples. Number 4. SEM, or scanning electron microscope. This scientific equipment is used for the physical identification of various questioned specimens. It is a software-controlled digital scanning electron microscope used to produce stacking images over a wide range of magnification 3 times 3 million on rough or covered surface of minute specimen such as hair, fibers, paint particles, drugs, metal, and etc. Number 5. FTIR, Fourier Transform Infrared Spectroscopy, used for the identification of pure organic substances. It identifies organic substances, particularly abused drugs and explosive ingredients, based on their characteristic functional groups. In layman's term, the resulting spectrum could be referred to as the fingerprints of the substance. Chapter 2. Preservation and safekeeping of evidence. The following are the guidelines in the proper preservation and safekeeping of evidence. Number 1. Proper chain of custody shall always be observed. Number 2. All examined pieces of evidence, such as drugs and other paraphernalia, explosives, firearms, and all other chemistry-related evidence, shall be personally turned over by the examiner on case to the evidence custodian. The latter, in turn, shall execute its documentation by recording all received as well as released evidence for court presentation. No examiners shall keep in their possession their possession evidence once examined. Number 3. Evidence shall be properly placed in suitable dry containers for proper preservation and shall be placed inside the concrete evidence room. Firearms evidence shall be kept in a separate evidence room specially designed for the purpose. However, hazardous evidence such as explosives and other inflammable evidence are photographed after examination with its corresponding case number before turning it over to Explosive Ordnance Disposal Unit or EODU with proper receipt for safekeeping or proper disposal. Chapter 3. Development of Scientific Crime Laboratory in the Philippines. February 14, 1829. Massacre occurred in Chicago. Then a group of public-minded individuals was responsible for the establishment of a scientific crime laboratory in that city, which today has marked its place in the historical annals of police science. March 31, 1876. Creation of medicos titulares by virtue of Royal Decree number 188 of Spain. For every province, a forensic physician was assigned to perform public sanitary duties and at the same time provide medico-legal aids to the administration of justice. December 15, 1884. Governor-General Joaquin Javelier created a committee to study the mineral waters of Luzon and appointed Anacleto del Rosario as chemist. September 13, 1887. Establishment of Laboratorio Municipal de Manila under the inspection of the Direction General de Administración Civil and the control of the Gobierno de Provincias. The function of the laboratory was to make analysis not only of food, water, and others from the standpoint of public health and legal medicine, but also of specimen for clinical purposes. 1894. Laboratorio Medico-Legal was created under the dependency of the judicial branch of the government and the laboratory functioning under the direction of physician and assisted by a pharmacist chemist. 1895. Antonio Lona established a clinical laboratory where some original works in the chemistry were done. Unfortunately, all prospects of the advancement of the scientific laboratories were paralyzed as a result of the revolution in 1896. 1899. The first scientific laboratory was established in a small building on the banks of Pasig River with Lieutenant R.P. Strong of the U.S. Army in charge. 1901. Actual scientific work began under the initiative of Dean C. Worcester by virtue of Act Number 156 approved by the Civil Commission. July 1, 1901. The Bureau of Government Laboratories was created for the purpose of performing biological and chemical examinations as well as for the production of vaccines and sera. March 11, 1915. The Department of Legal Medicine was created pursuant to the resolution of the Board of Regents. The department took charge of the courses of legal medicines and its branches in the College of Medicine and Law. October 14, 1924. Through the passage of Act No. 3043 by the Philippine Legislature, the same Department of Legal Medicine became a branch of the Department of Justice and at the same time an integral part of the University of the Philippines. December 1, 1937. The Division of Investigation was created under Commonwealth Act No. 181 with 2 medico-legal officers and a chemist. The medico-legal section of the Division of Investigation started the definite movement towards the creation of Scientific Crime Detection Laboratory. September 1945. The National Bureau of Investigation, or NBI, was organized with a Division of Investigation as the nucleus. The chemical laboratory of the medico-legal section was expanded into a forensic chemistry division. At present, there are 4 distinct laboratories in the Philippines performing forensic chemical analysis, namely, number 1, Forensic Chemistry Division of the NBI. Number 2, the Criminal Investigation Laboratory of the Manila Police Department. Number 3, the Criminal Investigation and Detection Laboratory of the Philippine Constabulary. And number 4, Manila Investigation Service Laboratory. Chapter 4. Scientific Evidence. Evidence is a proof of allegation. It is a means sanctioned by law of ascertaining in a judicial proceeding the truth respecting a matter of fact. Section Rule 128 Revised Rules on Evidence. Corollary thereto. Scientific evidence may be defined as the means sanctioned by law of ascertaining in a judicial proceeding the truth respecting a matter of fact wherein scientific knowledge is necessary. Such scientific evidence must have such a relation to the fact in issue as to induce belief in its existence or non-existence. Evidence on collateral matters shall not be allowed, except when it tends in any reasonable degree to establish the probability or improbability of the fact in issue. Evidence may be letter A, direct, letter B, indirect, which includes circumstantial evidence, and C, hearsay. Letter A, direct evidence, is that which the senses perceive, any fact to which a witness testifies based on what he saw, heard, smelled, touched, or tasted is direct. Crimes are done secretly. Usually, the perpetrator seeks darkness and remoteness in order to cover his misdeeds, and in most cases, no witness is present at the scene of the crime, or even if there are witnesses, he or they are not willing to testify. The necessity of resorting to other means of proof is essential. Hence, it is necessary to use all other available modes of procuring evidence in order to establish and prove a case in court. Letter B. Circumstantial evidence is a kind of evidence which seeks to establish a conclusion by interference from the facts proven. Illustrative case. While a policeman was patrolling, he heard a scream from a house. He immediately proceeded to the house and then he saw a man coming out of the house carrying a bloody knife. The policeman arrested the man and subsequently entered the house. There, he saw a female cadaver lying on the floor with a stab wound on the breast. In this case, the only direct evidence to which the policeman can testify would be to the fact that he saw the man with a bloody knife coming out of the house where the scream came from. The prosecutor may establish a conclusion that the man with the bloody knife is the criminal by inference from the facts testified to by the policeman. Under the present law, circumstantial evidence is sufficient for conviction if, letter A, there is more than one circumstance, letter B, the facts from which the inferences are derived and proven, and letter C, the combination of all circumstances is such as to produce conviction beyond reasonable doubt. Letter C. Hearsay evidence is a statement made by a witness on the authority of another and not from his own personal knowledge or observation. Hearsay evidence is inadmissible except on the following. Number 1. Dying declaration. Number 2. Res gestae. Number 3. Declaration against interest. Number 4. Act or declaration about pedigree. Number 5. Family reputation or tradition regarding pedigree. Number 6. Commonly reputation. Number 7. Part of res gestae. Number 8. Entries in the course of business. Number 9. Entries in official records. Number 10. Learned treatise. And number 11. Testimony or disposition at a former proceeding. Forms of scientific evidence. Letter A. Real or autoptic evidence is that evidence which is addressed to the senses of the court. It is not limited to that which can be known by the sense of vision but extends to those which are perceived by the senses of hearing, taste, smell, or touch. Letter B. Testimonial evidence. An expert may be called on the witness stand to answer all questions propounded by both parties in the case. Letter C. Documentary evidence. Any written evidence presented by an expert in court which is relevant to the subject matter in dispute and not excluded by the rules of court. Formal written report, expert opinion, certificates, and dispositions are included in this group. The investigator is a fact finder. It is a basic that he must know the laws concerning the nature of his investigation. He should procure evidence in such a way that the findings can be admitted in court and remain impregnable against any attack by the opposing counsel. He should be in constant contact with various investigative and enforcement agencies. Chapter 5. Witness. A witness in court may be an ordinary or expert witness. Under the law, an ordinary witness must have the following qualifications. Number 1. He must have the organ and power to perceive. Number 2. Perceiving can make known his perception to others. Number 3. He does not fall in any of the exception provided for by Law 123 Rules of Court. The opinion of a witness regarding a question of science, art, or trade, where he is skilled therein, may be received in evidence. This kind of evidence is called the testimony of an expert witness. Distinctions between an ordinary and an expert witness. Probative value of expert testimony, whether courts are or are not bound by the testimony of an expert, depends upon the nature of the subject of inquiry. If the subject of inquiry comes within the general knowledge of the judge, the latter will not be bound by the conclusion of the expert. For instance, when the subject of inquiry is genuineness of a handwriting as compared to a standard. However, when the subject of inquiry is of such a nature that a layman can have no knowledge thereof, as for instance the determination of parentage through DNA test, the court must depend on result of the examination of an expert. Qualifications of an expert witness. Letter A. The degree of learning of the witness. Letter B. The basis of logic of his conclusions. And letter C. The other proof of case. Chapter 6. Drugs. Drug is a chemical substance that brings about physical, physiological, behavioral, and psychological change in a person taking it. All medicines are drugs, but not all drugs are medicine drug. Medical drugs, a substance which, when taken into the human body, cures illness and relieves signs or symptoms of disease. Dangerous drugs, a substance affecting in the central nervous system, which when taken into the human body brings about physical, emotional, or behavioral changes in a person taking it. Drug abuse, any non-medical use of drugs that cause physical, psychological, legal, economic, or social damage to the user or to people affected by the user's behavior. Abuse usually refers to illegal drugs, but may also be applicable to drugs that are available legally, such as prescribed medications and certain over-the-counter medications. Classification of drugs. According to origin, natural drugs are active ingredients, secondary metabolic products of plants and other living systems that may be isolated by extraction. Examples: raw opium, marijuana, and coca bush. Letter B. Synthetic drugs are artificially produced substances synthesized in the laboratory for the illicit market, which are almost wholly manufactured from chemical compounds in illicit laboratories. Example, methamphetamine or methamphetamine. And number two example is barbiturates. According to legal classification, letter A, RA 9165, Comprehensive Dangerous Act of 2002. Letter B, PD or Presidential Decree 1619, Volatile Substances. And letter C, RA 6425, classified as regulated and prohibited. Under RA 9165, otherwise known as the Comprehensive Dangerous Drugs Act of 2002, the term prohibited and regulated was changed into dangerous drug with the following classification. Number 1. Immediate precursors. A chemical substance used in the clandestine manufacturing process becomes incorporated in full or part into the final molecules of substance under international control as reagent or solvent in the illegal manufacture of controlled substances. Number 2. Narcotic, psychotropic, and designer. According to international classification, letter A, narcotic substance. Letter B, psychotropic substances. Letter C, designer drugs. According to pharmacological classification, effects. Letter A, stimulants. Letter B, hallucinogens. Letter C, depressants. And letter D, inhalants. Stimulants are drugs which increase alertness of physical disposition. Number 1. Narcotics. A drug which induces sleep or stupor and relieve pain. Something that soothes or causes a sensation of mental numbness. This includes opium, opiates, heroin, morphine, and codeine. Tranquilizers, a substance that reduces anxiety, ease tension, and relax muscles. Sedatives and hypnotics, calm the nerves and reduce tension and induce sleep. Inhalants, these are any liquid, solid, or mixed substance that has the property of releasing toxic vapors or fumes. What are considered dangerous drugs? Dangerous drug is a substance affecting the central nervous system which, when taken into the human body, brings about physical, emotional, or behavioral changes in a person taking it. It is a substance which when taken into the human body, alters mood, perception, feelings, and behavior. Prohibited drug, which includes opium and its active components and derivatives such as heroin and morphine, coca leaf and its derivatives, principally cocaine, alpha, and beta-eucaine. Letter B, regulated drug, which includes self-inducing sedatives such as secobarbital, phenobarbital, which contains a salt or a derivative of a salt of barbituric acid. Letter C, volatile substance, liquid, solid, or mixed substances having the property of releasing toxic vapors of fumes or any chemical substance which, when sniffed, smelled, inhaled, or introduced into physiological system of the body, produce or induce a condition of intoxication, inebriation, excitement, stupefaction, stupefaction, and etc.